Good afternoon, ladies and gentlemen. It's Tuesday, March the 7th, 2023. Welcome to Civil Justice Subcommittee. Madam Clerk, please take the roll.
Good afternoon, Representative Beck. Here. Oh, thank you. Bolso. Here. Capley. I'm here. Eldridge. Here. Farmer. Right here. Grills. Here. Lambert. Bolso. Parkinson. Here on time. Todd. Here. And Chairman Russell.
Here.
Chairman, you have a quorum.
And members, do we have any personal orders today? Seeing none, we'll begin with three people on the committee telling a little bit about themselves today. And Representative Bolso, would you like to start out telling when you was first elected, what area you represent, and what you do on the times you're not in the legislature?
Yes, thank you, Mr. Chairman. Delighted to. I'm Gino Bolso. I represent District 61, which is most of the city of Brentwood, Tennessee, and a good chunk of Franklin, Tennessee. The district expands west across Old Hickory Boulevard to Horseshoe Bend subdivision, and then down to Sneed Road, farther west out to Temple Hills, and then down to 96. I am a trial lawyer by training. I've been practicing law in Tennessee now for about 36 years. I've tried probably more than 125 cases over the years in state and federal courts in Tennessee and across the country. When I'm not here in the legislature or working at the law practice, I'm spending time with my grandchildren. My wife, Kathy, and I have got 5 children, all of whom are now grown. We've got 7 grandchildren, ages 5 and under, so they're a lot of fun. And when I'm not doing that, I try to play a little bit of tennis. I actually grew up down in Florida and was recruited to go play tennis at Cornell College back in 1979, so I still play competitively in USTA events across the country. And whenever I can steal some time from the legislative work and the legal work to play tennis, you might find me on a clay court somewhere close by. Thank you, Mr. Chairman.
Thank you, Representative Bolso. We appreciate you on this committee. And Representative Beck, would you tell a little bit about yourself?
Thank you, Mr. Chairman. My name is Bill Beck. I represent District 51, which you're sitting in, so everyone welcome. I am also a trial lawyer and have been, this is my 5th term in the legislature. It's an amazing place, and we're glad that you all are here to make your voices heard. Let's see, I graduated from Belmont College, went on to Nashville School of Law, and I have a beautiful wife, Pam, who just retired from TBI. And we have one daughter who will admit me to the grandparent club in August. So I'm very excited. Thank you very much.
Thank you, Representative Beck, and we appreciate you. And Leader Lambert, would you like to tell about yourself?
Thank you, Mr. Chairman. I was first elected in 2012 with Chairman Farmer, who I think stepped out of the room for a moment, but we had a really good class that came in. A lot of us are still here. I represent part of Sumner County, coming all the way really from the southern part up through the middle up into northern Sumner County, where I grew up. Where my family's 5th generation residents of Sumner County. My children will make 6th generation if they stick around there. I hope that they do. I am an attorney. It's what I do for a living. I'm a former prosecutor and in private practice now, but my best gig I've got is I'm a dad to 2 kids, Allison and Pierce, and husband to a wonderful wife. It is, in fact, my little girl's 14th birthday today, so happy birthday, Allison. Thank you, Mr. Chairman.
Thank you, and we appreciate your leadership. And my brother Corey's birthday is today, so happy birthday, Corey, if you're watching. I know you probably are. But anyways, ladies and gentlemen, we introduce members of the committee every week to remind us all that we're just servants of the people, just Tennesseans like you all are, and we come from different backgrounds to look at these bills uniquely. So we'll start with our calendar today, but before we begin, House Bill 237 will be rolled to our final calendar. That brings us to item number 2, House Bill 9. Excuse me. Item number 2, House Bill 977 by Representative Warner. We've got a motion and a second. Representative Warner, you are recognized, and I do show an amendment.
Yes, sir. Thank you, Mr. Chairman and committee. It's an honor to be here in front of you today.
Do I have a motion and a second on the amendment? Motion and a second. And does the amendment make the bill?
It adds to the bill, sir.
Okay. Okay, we'll go ahead and recognize you to speak on the bill, and then we'll add the amendment later. You're recognized.
Okay. Oh, we'll add it. House Bill 977 simplifies, and I want to apologize. I've got a cough drop in. If I don't keep it in, I'll get started coughing, so I apologize for that. Simplifies the complex and contradictory language to the current law relating to weapons on educational property. It clearly defines where lawful behavior ends and where criminal behavior begins. The current language is littered with murky, contradictory, and unclear boundaries between permitted behavior and felonies. This bill allows a regular person to understand when they are crossing the line of criminal behavior. It decriminalizes innocent, everyday conduct, such as parents forgetting that they are carrying a pocket knife when picking up a child from school, voting, or attending a football game, which is currently a felony and ruins the lives of people who never intend to do anything forbidden. Under current law, nobody can know for sure whether they are allowed to carry a knife or gun somewhere on public property or not, as the law is so broad and vague. The same park, plaza, or greenway is sometimes fine and sometimes not, and you have no way of knowing when you're committing a felony. This law makes it clear and predictable by giving people a chance to know when the weapons are banned. By the way, this bill does not allow intoxicated police officers to carry. That is prohibited in 39-17-1321. This bill does, however, allow college students, university professors, and staff to protect themselves. Reduces felony traps for individuals already authorized to carry handguns on educational property. It gets Tennessee law in line with the federal requirements under the U.S. Supreme Court's Bruin decision. It clarifies that college and university students, as well as staff, are allowed to carry pepper spray for lawful self-defense. Why is this important? Section 39-17-1309 is complicated and contradictory. It is littered with the felony traps, again, to criminalizing innocent behavior. Young adults are currently easy targets for robbery, rape, and other violent crimes while on campus, even though they go through all the vetting and training to obtain an enhanced carry permit. Under current law, they will commit a felony if they try to protect themselves. With that, Mr. Chairman, I'm ready to stand for any questions or add the amendment. The amendment's going to clear up some of the questions I know that's about to come. So,
And thank you for that, Representative Warner. And would you just sort of describe the amendment? Let's go ahead and identify the amendment code. If you'll tell me the number you have at the bottom right.
it is 3720.
That's what I show. And do we have a motion and a second on the amendment? We have it? And, okay. And will you go ahead and tell us
Yes,
about the amendment?
the amendment clears up two things. When we're talking about this bill and anything in this bill, you must have an enhanced gun carry permit. That's someone who's been through 8 hours of training, and I think it's the toughest gun permit we have here in the state, the most stringent or whatnot. Delete Section 5, which clears the language and deals with the intoxication of police officers. That was never the intent of the bill. I don't know, something may have been, addressed in there that did delete a little bit of that, but that's covered other places in code, and this deletes that section, so that is not an issue anymore.
Thank you. We'll be voting on adding Amendment 3722, House Bill 977. All those in favor signify by saying aye. Opposed, no. The ayes prevail. All right, Representative Warner, you are recognized on the bill, and since you've already spoke to the bill, we'll go ahead and start with Leader Lambert. You're recognized.
Thank you, Mr. Chairman. And I want to, just on the amendment and again, we want to get in the posture that you wish to have it on. I know it fixed a couple things with deleting Section 5. I'm still trying to determine on subsection G, when looking at the amendment, the 3720 we just put on, and looking at the bill as filed, what's the intent to change between the amendment and what's in the original bill? I just want to make sure that I'm fully understanding what you wish to change and the goal was to change with the amendment versus the original bill as filed.
Deleting where it talks about the intoxicated police officers, and making sure that that everybody knows that we are talking about enhanced gun permit holders
Leader Lambert.
being able to carry on a college campus.
Okay, thank you. So that's what you want to make sure that amendment did, is that it, in the original bill, it was anyone could carry, and in the amendment, it's enhanced carry permit holders only.
Enhanced.
Representative Warner,
Yes.
you're recognized.
Yes, sir. I apologize, but yes, sir, that is the case.
Leader Lambert.
Thank you, and I just wanted to highlight that. I mean, I was double checking what I was reading there was accurate, and I also wanted to make sure that it got in the posture that you desired it to be. And Mr. Chairman, I know there's testimony, I may have some questions afterwards, but mainly I just wanted to make sure it was in the posture the sponsor wanted it to be.
Thank you. And if it's all right with everybody, we'll go out of session and hear from some people that came down to testify. So without objection, we're out of session. And Chloe Hammond. Chloe Hammond. You'll come down to the testifying table there. Make sure your little red light's on, and you'll have 3 minutes. You'll identify yourself to the committee, and when you start speaking, we'll start timing. And is your red light on? Yeah, it is. Okay. We can't hear you.
Is this a little bit better?
That's
okay.
better. If you'll
Here
just
we go.
identify yourself to the committee, you'll have 3 minutes.
All right, yes. My name is Chloe Hammond, and I'm a senior at Middle Tennessee State University with a political science major and philosophy minor. I am appreciative of this opportunity to stand before you all and discuss my support for the 977 bill. Let us discuss the importance of this bill in protecting the young students. Criminals remain unbridled with power on the university campus. They have low risk and high opportunity to prey upon the unprotected student body, myself included. The current Tennessee law renders individuals such as me in a vulnerable position with no means of protection. Criminals blatantly defy the law to achieve their motives, and innocent, law-abiding students will be the ones who bear the consequences. This bill permits law-abiding students, such as myself, to possess a practical means of self-defense, whether it be a knife, a pepper spray, or a firearm, on the institutional grounds. This bill further deters criminal activity from taking place by increasing the risks that criminals must take to execute their unlawful behaviors as they seek to prey upon me and my fellow students. Critics may question the responsibility of college students with weapons on university grounds in light of common stigmas that are associated with college life. To this, the Tennessee law already prohibits carrying weapons under the influence of drugs or alcohol. I should never be denied the right to defend myself because of the stigma of others, and if this argument were to hold up, the state should deny the ability for students to possess transportation on school grounds versus infringing upon my Second Amendment right and my right to self-defense. I'm reminded of my time spent at the University of Redlands in Southern California. Late into the evening, near COVID, the university issued a warning to students concerning a violent robbery that took place on campus. The assaulted student was severely injured and outnumbered by the perpetrators and left with no means of fending off these attackers. I'm 22 years old. I'm 130 pounds and 5'2" in stature. I attend night classes from the hours of 6 to 9 p.m. twice a week on campus. At these hours, the student presence has dwindled greatly, and I walk across the campus defenseless on these nights, returning to my vehicle with that assault in the forefront of my mind. I have had to call campus police myself and witness firsthand the 20-minute response time, leaving a defenseless woman such as myself at the mercy of violent criminals who wish me harm. The reasonable person understands the dangers and implications of self-defense, the tools involved, and possess the knowledge to use them when their life is in jeopardy. Thank you all.
Thank you, Ms. Hammond. Any questions for Ms. Hammond? Representative Todd?
Thank you, Mr. Chairman. I appreciate you being here today and giving us this testimony of your personal experience and your concerns. I've heard similar concerns from my daughter on the college campus who's still there in another state. And so I get that. And as a father, it gives me great concern with her going across campus at odd hours due to her class schedule and knowing that there's a tremendous lack of officers that can protect her. I mean, I don't know what the ratio probably is, but it's probably one officer to 5,000 or 6,000 students, and most of our communities are probably a greater ratio than that if you talk about the average citizen. So thank you for being willing to come and share this with us.
Ms.
It was an
Hammond?
honor.
Okay. Representative Kepley.
Thank you, Mr. Chairman. Thank you for coming today. I was also a political science major at MTSU, so I would imagine that you have several classes in Peck Hall. Is that correct?
My entire semester and all my classes are in Peck Hall, yes.
That's kind of what I imagined. Members, let me describe the absolute nightmare of what Peck Hall is at MTSU. Imagine a perfect square, and in the center of that perfect square is another square. The center square is staircases. The outside square is straight line vertical hallways. If an active shooter entered Peck Hall, it would be an absolute disaster. There would be no form of safety. There would be no form of recourse. It would be an absolute disaster for everyone within that building. Thank you for sharing your concerns. I had many night classes at MTSU as well. I'm 6'4", 265 pounds, and I worried about my own safety. So trust me, we're with you. Thank you so much.
Thank you.
Thank you. All right. Thank you for being here. We appreciate your testimony. And next we'll call up Kayla Lewis. Kayla Lewis. And Ms. Lewis, if you'll just make sure your red light's on, if you'll tell the committee who you are, and you'll have 3 minutes.
My name is Kayla Lewis. I am a small business owner and mom of 3, one of those being a little girl. There is a significant difference between the illusion of safety and actually being safe. Over 40% of women in the United States will encounter sexual violence in their lifetime. Almost 80% of those women experience their first attack by the age of 25. This statistic is important because it encompasses the traditionally attended college years. When I was a junior at UT Martin in the fall of 2009, there was a serial rapist attacking college-age girls in the area. Then it happened. In a place where people, especially women, are legally disarmed and made incapable of defending themselves, he made his way onto our campus. At gunpoint, he forced a female student to tie her parents up. With no way to fight back, no way for her parents to protect her, they were forced to watch on as he violently raped and sodomized her. It is a thing of nightmares, something so violent and brutal happening so close to home. She and her parents have to live with the physical and mental scars of that attack for the rest of their lives. The No Guns on Campus policy did the opposite of protecting that young girl. It ensured that her rapist had an unarmed victim that could not fight back. A couple years after this incident, I was living in my own place in my hometown. One evening, I stopped by my local gas station, just like I had done dozens of times before, and inside, 2 men waiting in line told me to go ahead in front of them. I politely thanked them, moved forward, and began my checkout process. I immediately regretted my decision. They began describing vulgar and violent, sexually explicit acts that they wanted to perform on me. I did my best to ignore it until one of them tapped me on the shoulder and said, "Give me your number." Trying to remain non-confrontational and giving him an out, I said, "No thanks, I'm married." He then proceeded to grab my shoulder. He forcibly spinning me around and pressed his body into mine and stated, "I didn't ask if you were married. I said, give me your number, bitch." I left my things on the counter, money included, and told them to leave me alone as I made my way out of the store. The 2 men began to follow me outside despite the clerk's threats of calling 911. When I got outside, I ran towards my car and they picked up speed behind me. I was terrified they were going to force themselves on me, terrified they were going to do all of the vile and disgusting things that they had discussed in the store. I reached into my purse, faced them, drew my gun, and yelled, "Stop." It worked. They immediately stopped in their tracks and resorted to verbal attacks and name-calling. I was the lucky one. I was able to escape, and I was able to defend myself. I believe in my heart that the only reason I wasn't further physically attacked, raped, and murdered was because I had a gun on me to protect myself that day. Someone else's presence did not stop them. Threats of the police did not stop them. What stopped them was a girl with a gun and the ability to defend herself. Both of these attacks were sexually motivated. Both of these attacks involved men preying on women. Both of these attacks involved disparity of force. It's not only unreasonable that mere location can have such a big impact on outcome, it's blatantly unacceptable.
Ms. Lewis, thank you. That's your 3 minutes, and we got plenty of time for questions. And any questions for Ms. Lewis? Representative Grills.
Thank you, Mr. Chairman, and thank you for coming and giving a heartfelt explanation of what happened to you in your life.
Yes, sir.
I'm grateful that you were not a statistic that day. I would love to know what the amount of crimes are subverted because people like you have the ability to defend themselves.
The CDC's smallest number says 65,000 people a year draw their guns and do not have to fire them in self-defense.
Representative Grills.
That's 65,000 people, according to the CDC,
In the United States.
that are not have that are
And
not
that's
part
the
of a
smallest
statistic.
number that I found. The largest one went up to 2.2 million. But I wanted to use a verified source, and I believe that the CDC is that.
Thank you. Any other questions? Wow. All right, next up will be Toby.
Thank you.
Thank you, Ms. Lewis, for your testimony. Toby's Meyer.
Mr. Chairman, while he's coming up, if I may, Toby helped with a lot of this legislation, so if you have any good tough questions, now would be a good time to get them out for Toby.
Thank you. And Toby, if you just make sure your red light's on, introduce yourself to the committee. I think everybody knows you, but you have 3 minutes.
Thank you, Mr. Chairman. Thank you, committee members, and thank you, Representative Warner, for bringing this awesome and important legislation. And yeah, I don't want to say anything that's redundant. The only thing that I would like to add in addition is that I always like the law to be simple. And it's strange for this to probably come from yet another lawyer, but I actually want the average high school dropout to be able to read the law and understand it, at least when it comes to criminal law. And unfortunately, right now, that is not the case for 1309. 3917, 1309, which is the section that governs firearms on educational property. I think everybody in this room probably, or there's probably a lot of desire to keep guns out of school, and this bill actually does that. It says that K through 12 educational property is still off limits. Some people would like to change that, but that's a different topic. This bill doesn't do that. What it does, it clearly defines for the average person to see this is a boundary where you are leaving permitted territory and starting to commit a felony, because right now that is not the case. Right now, for example, if you walk, let's say, across the Legislative Plaza, and let's say a college group is doing a theater rehearsal there, you're all of a sudden committing a crime if you have a pocket knife or a handgun on you. Let's say if a school board is having a meeting in an adjacent meeting room, anyone who is carrying a pocket knife or a firearm in this room would be committing a crime without having any advance notice. Let's say someone who went through all the process to get an enhanced handgun carry permit and get the university's authorization to, under the complexity of this absurdly long and complex law, be authorized to carry a handgun. Even that person will constantly run into the risk of committing a felony when, for example, the topic of a conversation changes. And I vowed to quote last TCA code this year, but I'm happy to point out the section if anybody wants to hear it. A few absurd examples, but I also don't want to waste a lot of your time. But what I love about this bill is it solidifies 3 sections into one. It shortens the code and makes the code simpler and makes understandable for people where the boundary is of what's permitted. Also, it does not prevent anybody from adopting a policy and saying, hey, we still don't want you to carry a firearm. Now, we're not encouraging that. What this law does, it takes away the automatic criminal liability for people on public property that's not school property, and for university campuses, as long as the person has an enhanced handgun carry permit, which is the toughest permit to get. So not for concealed handgun carry permits and not for permitless carry. And with that, I'm available for any questions, and I appreciate your time.
Thank you, Mr. Meyer. Is there any questions for Mr. Meyer? Any question? And Representative Bolzo.
Mr. Meyer, thank you for being here this afternoon. I will take Representative Warner's recommendation and prevail upon your expertise in Tennessee's criminal code. First, could you give us a summary of the current law as it relates to one's ability to carry a weapon, including a firearm, on school property, both K through 12 and higher education?
Mr. Meyer.
Yeah, thank you, Mr. Chairman. Thank you, Representative Bolso. So TCA Section 3917-1309 makes it a felony to possess with the intent to go armed practically anything that can be used or abused as a weapon, unless it's something that's specifically for personal hygiene only, which is defined in 1309A. Basically anything else, be that a pocket knife, be that there's a bunch of things listed there, slingshot, dagger, whatever. It's actually a Class E felony to possess this, not just on school property, but on any public or private property that is owned currently in I'm citing here from recollection of memory, but roughly any property that is owned, operated, under control, or currently in use by a school, college, university, board of education, or board of trustees of any educational institution. Now, when it comes to schools, that's usually pretty obvious. But the problem is any public property, be that a park or be that any other public building that a school is using for any purpose. That's where it becomes really murky, and that's where it becomes practically impossible for anybody to actually comply with.
Representative Bolso.
Thank you, Mr. Chairman. Mr. Meyer, if House Bill 977 is enacted, how will it change 39-17-1309 as you have just summarized it for us?
Mr. Myers.
Thank you, Mr. Chairman. Thank you, Representative Bolso. So it will basically still prohibit firearms on K through 12 school property. It will still make it automatically a criminal offense for anybody to carry a weapon on such property, unless if the property is properly posted. So basically, if you can see that it's that it's prohibited property, then you're committing a criminal offense if you're breaking that. But it will, for example, no longer make it automatically a crime if you, let's say, on a greenway, and somewhere on the other end of the greenway, a college group is doing a 5K or something like that, that you may have no chance under current law to be aware of, but under current law, you're committing a criminal offense.
Representative Bolso.
Thank you, Mr. Chairman. One final follow-up. Mr. Meyer, if HB 977 is enacted, who will now be able to bring a weapon onto school property, and on what property will they actually be able to bring the weapon?
Mr. Meyer.
Thank you. So if you're referring to school property, pretty much only the same people that are currently allowed to carry a weapon on school property. Primarily police officers, but there's even a lot of restrictions for police officers. It becomes slightly more predictable. I believe the original version of the bill wanted to delete a few more ambiguities there, but it's still making it a little bit more predictable for police officers when they're in compliance with the law. Because right now, it's actually so narrowly worded that even if a police officer is, for example, outside the scope of their employment, so let's say, for example, you're let's say, Williamson County Sheriff's Department employee, and you pick up your child after school, let's say in Robertson County, you're committing a felony under current law. Also, for example, if you are one of the employees currently authorized to carry a firearm on college property, and you're in a meeting with your colleagues, and let's say, for example, let's say, to make a fictional example, let's say, Professor Parkinson and I are talking about making adjunct Professor Warner an associate. Let's say if you were attending this meeting and you're authorized to carry a firearm, you're now all of a sudden committing a felony. Up until this moment, you were perfectly fine. But because the subject now changed to a tenure issue under current law, and if I remember correctly, to give you an example, is, if I remember correctly, TCA Section 3917-1309, and now brace yourself, Subdivision E, 11C, Roman V, E. the subject changes to tenure and you're committing a felony. So we're now, just as an example, the sixth layer into the exception to the exception of the exception of the definition of the rule. And we're not even all the way to the bottom, because TCS section 39, 17, 13, and 10 provides defenses to some of the exceptions to the exception to the exception. This is what I mean by I like to simplify the law.
Representative Bolzo.
Thank you, Mr. Chairman. If I may ask a last question. Let me narrow the question a bit, Mr. Meyer, to college campuses. And obviously, we've just heard this compelling testimony from Ms. Hammond and Ms. Lewis. How will this bill, if enacted, change one's ability to carry weapons onto college campuses in Tennessee?
Mr. Meyer.
So for college campuses, thank you. For college campuses, it will allow people with an enhanced handgun carry permit to carry a firearm onto to college campuses. So we're talking about people who have taken an at least 8-hour class that includes training about firearm safety, about firearms laws, that includes a shooting test with a certain level of marksmanship required, that requires a background check and vetting. It will allow only those individuals to carry a firearm on college and university campus property, if not otherwise prohibited, visibly prohibited. And with that, we're talking about the highest level of permit that exists in Tennessee. So it does not include concealed handgun carry permits, and it does not allow permitless carry either.
Representative Bolzo. Thank you, Mr. Chairman. We're going to move on, but I want to ask one question to clarify. These postings on the school campuses, can it just be at the entrances, or does it have to be each individual building?
Thank you, Mr. Chairman. So under current law, anyone being physically present on any educational property or property being used, even or owned or anything like that, whether visible, recognizable or not, carrying either a knife or a firearm or anything that can be used as a weapon practically, is committing a criminal offense, whether it's visible or not. Under this bill, it would only be if the property is visible as firearms being prohibited. So what you're, if I understand your question correctly, such a place would still be allowed and free to put up a sign that says no firearms allowed. They could, for example, restrict it under TCA section 39, 17, 13, 59, just like any other place can. But that would be voluntary. That would be optional for the university to decide, so to say.
So for a university to post it, could they post it at one location at the entrance, or do they have to post it for each individual building they have and each individual sporting venue?
Thank you, Mr. Chairman. So that depends on what consequences the university wants to attach to it. So they can just put up a sign anywhere, whichever they want, and they can still refuse anybody entry who refuses to comply with that. They can ask anybody to leave who doesn't comply with that. Anybody who refuses to leave then automatically commits criminal trespass. If I remember correctly, that's section 39-14-405. If they want an automatic criminal liability attached to just the fact that the person possesses a firearm, then if I remember correctly, the law currently requires this posting to be placed at all the entrances that are commonly used, basically to give people, again, a notice of the fact that they are committing a crime.
Thank you. Representative Todd, you're recognized.
I just had one question about tasers. I don't know that that's included, but I wanted to make sure I hadn't missed it. If someone, does this allow someone to carry a taser for protection on a college campus, for example?
Mr. Meyer.
So I believe the law would be, unless there is something that I'm not aware of that prohibits tasers, silent on that. The law specifically allows pepper spray. And it specifically allows firearms for a person who is authorized to carry a firearm. It would ban or is still under current law, bans practically anything that can be used as a weapon on school property. But I think the law is silent either way on that right now. So this bill actually doesn't change the law in that regard at all.
Representative Todd. All right, Chairman Farmer.
Just real quick, this should just be a yes or no answer that I'm asking you. I was going to follow up on what Representative Bolzo had to ask you. Can a person with a enhanced carry permit carry on a K through 12 school property under this bill?
Mr. Meyer.
The answer is generally no.
Okay, thank you. Thank you.
Leader Lambert.
I want to follow up on what Chairman Todd mentioned. I mean, there's a lot of detail on this, and by the way, thank you for young ladies for testifying, and thanks for bringing the bill. I mean, I actually support the direction this is going, but there seems to be a lot of moving parts here I still have questions about. First of all, the taser question, I mean, it specifies out pocket knife, pepper spray, pepper gel, or mace. I mean, don't you think that by not listing tasers that we are implicitly precluding them from this? I mean, I worry about a young lady carrying a taser. I've recommended that to young ladies and young gentlemen, quite frankly. Folks are more likely to use a contact taser for their own defense. They feel more comfortable with it. Was that just an oversight, or was that purposeful to leave tasers off the list?
Mr. Meyer.
Yeah, thank you, Mr. Chairman. Thank you, Leader Lambert. To my knowledge, there was no intention to include or exclude them, but I agree with you. So, I mean, that'd be a good thing to add.
Leader Lambert.
Thank you, Mr. Chairman. And he said something a while ago, and I want to make sure I understand it right. I mean, you were saying that this bill resolves the issue of dropping off and picking up children. Are you talking about on college campuses or on K through 12? Because K through 12, that issue's already dealt with in the law. You can pull up to your child's school as long as obviously the firearm remains in the vehicle, pick up your children, and there's no criminal offense there at all. So what does this change about that?
Mr. Meyer.
Thank you. It changes when a person leaves the motor vehicle. Right now, what you're referring to, if I understand this correctly, is what's covered by Section 1313. When the person leaves the vehicle, then so 1313 is what allows people to carry a firearm in their motor vehicle, and it allows, if I remember correctly, non-student. I think actually there may be a part in 1309 that says non-student adults. I do remember non-student adults are permitted to, within very, very limited circumstances, to have a firearm in their vehicle as long as it's not open to observation, is not being handled by the adult non-student. So that would be, let's say, a parent who is in their car and remains in their car while picking up the kid. The problem is the moment the person exits the motor vehicle, the person is no longer covered by that section and is actually committing a criminal offense. So what this bill, and the bill actually doesn't do anything about that as far as firearms concerned at all. What this bill only decriminalizes is a person having a pocket knife. So let's say right now, if a parent picks up a child from school, right now, if a person picks up a child from school right now and has a pocket knife and forgets about that, right now they're committing a felony under 1309 B. And this bill basically clarifies that a non-student adult who is lawfully on that school property is allowed to have a pocket knife in their school, in their on their person.
Leader Lambert.
Well, and on that note, there's another bill carried by Representative Capley, which I like a lot. It's a really good bill that deals with carrying pocket knives on school property. I didn't notice anywhere in this bill where you actually defined pocket knife. When I was working with Representative Capley on that bill, there wasn't pocket knife defined in the code anywhere. So do you define that in this bill? I know Representative Warner mentioned you helped design and draft this. Is pocket knife defined anywhere in here?
Mr. Meyer.
Thank you. The answer is no, and that thought crossed my mind, and that is something that needs to be added indeed. Regarding that bill, by the way, which I like a lot as well, I like that it decriminalizes voting. Also, people have approached me who had felony convictions because, for example, they didn't realize that they had a pocket knife on them while they were attending a football game. Nothing was posted there, whatever, but they have a felony conviction on their record now. You know, the same is for parents picking up their children, which is, by the way, why this bill has a positive fiscal note, because apparently a bunch of people do get convicted for that every year and end up with a felony conviction. So, this basically just says if you have a right to be on that school, so not if you're doing anything prohibited, not if you are a criminal or whatever, but if you have a right to be on that school property for any reason, if you're a parent or if you're voting, like in Representative Capley's bill, then having a pepper spray or a pocket knife on you for lawful purposes is by itself not.
Leader Lamberth.
A couple other questions just under, and I can probably do these a couple in a row. And I know this is getting technical, but it's important we get this right.
You all just go back and forth.
Oh, thank you, Mr. Chairman. So under subsection E, it has always been that law enforcement officers, private security, security guards, and officers, which were in basically as part of their job, is while they were on duty, if you will, could carry in some of these other areas. But that's all taken out of this bill. Is there any reason why a private security guard would have greater rights than, say, you or I, to be able to carry in places that we can't? I mean, what would be the logic in that?
Well, this is weird. Okay.
Yeah.
Thank you, Mr. Chairman. Yeah, actually, I almost couldn't agree with you more. I would love for anybody to be allowed to carry basically any weapon for lawful purposes in any location. But I do understand that there is a lot of desire to keep certain locations off limits. And what we all agree on, we don't want bad people to commit bad acts. That's what we all agree on, and that's where the people that would not be comfortable to go that far. Would probably say, well, we don't want people, to carry, certain things on school property. And my opinion on this is a person who is carefully vetted, carefully enough to have, for example, an enhanced handgun carry permit is probably not the person to worry about, be that on school property or anywhere. So I completely agree with you there. And I mean, I would be very supportive of that. I know a lot of parents would be, but that's a political decision. I'm not a member.
So, question about 12. It says any person who is authorized to carry a weapon under federal law would also be allowed to carry in a school and everything else. Do you happen to have that list handy? I mean, federal law, when you say that, that is massive. I mean, there are, I would probably venture a guess, hundreds of thousands of federal laws, if not more. So what do we mean by that?
The answer to the question whether I have that list handy is actually no. I was told repeatedly that we cannot tell federal agencies what not to do, or that they're not authorized to do the things under state law that they are under federal laws. I mean, that's again a question of the conflict between federal and state law. But
well, but I mean, is there an example of maybe a couple of folks? So if it says any person who is authorized to carry a weapon under federal law, for instance, who?
I mean, let's say a U.S. Marshal or somebody working for the Secret Service, for the FBI.
Okay, all right. And then really, I think, and I'm going to try, unlike my friend Representative Bolso, I'm actually going to try for this to be my last question. He got two last questions. I'm going to try for one. Under, I think it's 3917, 1359F, we're taking out a sentence at the end that I am worried that would allow for some parks to go back to the way it used to be, where they could just post. We've gone away from that, and in fact, I carried a bill several years ago that did away with virtually every gun-free zone in the state. And if an area that was open, as you know, wanted to prohibit firearms in a specific area, they had to have one point of ingress and egress. They had to have a metal detector. They'd do bag checks and everything else. Because if they're going to prohibit you or I from having our firearm in there, then they'd better make sure that there is absolutely no one in that particular area. But removing that one sentence there, I'm worried that it would allow for just the signs to go back up. Have you looked at that possibility? Do you have any thoughts on that?
So I haven't. I have that in principle, that same concern. So basically, the part with this particular section is so and I appreciate you, Leader Lambert, because you're among the few people that that gets me to the edge of what I'm able to rattle off in terms of code. But I know that there's this subsection. It's something with H and I in 1309. There's a very similar language in 3917, 1311. That governs specifically the part on parks and greenway. And they have very similar but slightly different language. And the problem is that they have a lot of exceptions to the exception. So basically, they say, correct, that was that preemption, I think, in 2015, that basically took away from the municipalities that ability to post. It basically put another caveat in, which is basically if that park or greenway or any part of it is either owned, operated by, currently under control, or currently in use by any school, campus, university, college, board of education, board of trustees, or similar educational or other educational institution, roughly reciting here from memory. And that becomes really murky because the example, let's say, some college team is doing a theater rehearsal in a different part of the park, and somebody in that park, who's normally authorized to be there now is committing a criminal offense. So the intent is basically to take that out. Now, I'm, of course, 100% certain to basically, or on the same page, to do another clarification, kind of like, if I remember correctly, it's 3917, 1359G, that basically states specifically, hey, here's the preemption. Your municipalities cannot bar these locations. You've given me 2 or 3 really good ideas for additional amendments. I appreciate that.
Thank you very much. And like I said, I spoke with the sponsor beforehand, and that's really what I'm looking for here, and thank you for saying that, is just make sure we get this in the posture where it does exactly what we want it to do and not any more or less, so to speak, and that we don't undo any protections that we've already put out there for folks' Second Amendment rights. Thank you, Mr. Chairman, and thank you, sir.
Thank you. Thank you, Mr. Meyer. And Representative Beck, you're recognized.
Thank you, Mr. Chairman. And Mr. Meyer, just real quickly here. In answering the chairman's questions, it reads to me, and correct me where I'm wrong, that anyone with a enhanced carry permit is allowed, there's no discrepancy by the higher education as to where he can carry that where they can carry a firearm on campus. Is that correct or incorrect?
Mr. Meyer, you and Representative Beck can go back and forth. You don't need me.
Thank you, Mr. Chairman. Under the bill?
Yes.
Correct. Yeah, so basically under the bill, anybody with an enhanced handgun carry permit is by default allowed to carry on a university campus, correct. So if the university wants to bar certain locations, then they actually have to clarify that. They can, but under that law, by default, under that bill, by default, that person would be allowed to carry in all locations. And that is actually intended because right now, just like in the example with the 10-year, there are so many pitfalls and there are so many felony traps for the people that think that they jump through all the hoops, and they're not aware of, let's say, for example, under, I think that subdivision E11C, Roman numeral 5A, an auditorium is at certain times permitted for a person with an enhanced handgun carry permit who has all the authorization from the university to be in. But if there's a school-sanctioned activity going on there, then they are not. Same goes for a stadium. For example, someone who goes to, let's say, UT Knoxville, for example. Anybody who's familiar with that campus, there are a lot of university offices, I believe even classrooms in the Neyland Stadium. So, are they off limits under that, under the current law for someone who is specifically authorized? This bill actually clarifies that. So that if the university wants that part to be off limits, even for the people that are otherwise authorized, they have to put up a sign. Under current law, the people are in horrible gray area as far as are they committing a felony or not.
So without a posting, they could carry a gun into a UT game. Is that correct? Under this bill, unless the university were to prohibit it, that's basically the same rule as anywhere else. If you are not notified that you are not allowed to carry somewhere, then the default is that you are. The intention of the bill is to give people the opportunity to know when they are committing a crime. And the same question as to municipal and county facilities. If, for example, what if I had a enhanced carry permit and went to a Titans game?
So a Titans game is currently off limits, I believe, but that is the bill does not affect this at all because in fact actually don't quote me on this one because whether it's off limit or not is a private decision of whoever owns the Titan Stadium, so the Titans. If they prohibit firearms there, they can do that by putting up no firearms sign, and that's actually governed not by this law, and hence not affected by that bill. That's governed by a completely different section, which is Section 3917, 1359. So this bill won't affect Titans games either way.
But you mentioned in here municipalities or counties. If they own the land, how does that affect the right to carry in one of those stadiums or auditoriums?
So this bill
Under your bill.
So
Under this bill.
Yeah. So under this bill, this will change the law as far as property is concerned that is owned by or in use by an educational institution, college, school, university, etc., and basically make it predictable there whether or not that property is off limit. So basically any place that wants to prohibit firearms, they have to put up a sign to prohibit this. Right now, the law's murky on that one, and so people don't have the opportunity to know whether or not they're committing a crime. This bill basically attaches the criminal liability to the ability to identify the location as being prohibited. But by the way, this does not prohibit anybody from saying you cannot bring a firearm in here, or from asking anybody to leave. Now, there are certain preemptions as far as municipalities are concerned, but that's not under this bill. That's under, if I remember correctly, I believe Section 1316, so 3917, 1316, if I remember from memory correctly.
In Amendment 3720, it says eliminates Class A misdemeanor offense for the possessing of a firearm or other weapon on grounds of any park, playground, any other used, owned, and operated by a municipality, county, or state government for recreation purposes. So how does that affect?
It then also says in, I think it's the second paragraph thereafter, that it prohibits the carrying of weapons in K through 12 schools, to provide exception for certain persons, including any person to. So basically, it yes, it does take the current murky language away and replaces it with the clear language, K through 12 schools. So right now, the problem is that the same property is sometimes permitted and sometimes not. And the average person cannot know whether property is prohibited or not unless they pull title deeds for every single parcel of land that they're going to traverse, and in addition, know who all is going to meet there. So example, a school board having a meeting somewhere, let's say in this building, which is a public building, or somewhere on the plaza. Under the current law, is my understanding that will make that entire area off limits for anybody with a knife or with a firearm, even if they would otherwise be lawfully be there. This bill states, and that says, the fiscal note that you just said it in the third paragraph, prohibits the carrying of weapons in K through 12 schools.
I've got that, but property for recreational purposes owned by municipality is not necessarily K through 12 schools. I'm not sure why you're going back to that. How does this affect property owned by governments with intended for recreational purposes?
So the law already permits people to carry on that property normally right now. So normally all this property that you're just referring to, a person who is not prohibited from carrying a firearm is actually allowed to carry a weapon. Now, you can interpret 3917, 1311 to require people to have one of the two permits in order to be on such property. But the problem is that the current law, specifically Section 1309, makes it at times a felony for people to be on that property, and that is not always predictable. So this law makes it predictable. This bill makes it predictable what property is off limits and what not. So the property that you're referring to is already, municipalities are preempted. And I believe, again, Ms. Antonia can probably give a definite answer on that. I believe it's section 39, 17, 13, 16, or 14, one of the two, that preempts municipalities.
But the point is, you're removing any penalty for being on those recreational properties.
Because
in
right
this
now
bill.
the penalty only exists at certain times that are not predictable for the average person. So imagine a big park, and somewhere on the other end of the park, a group that happens to be affiliated with a college is doing a theater rehearsal, or
Hey, Toby, can I get legal just to clarify something real quick? Thank you.
Elizabeth and Sonia Legal Services. So the prohibition in 3917, 1311 on carrying in public parks, playgrounds, civic centers, recreational areas applies to anyone who doesn't fall into one of the exceptions. And there's an exception for enhanced handgun carry permit holders, but there is a general prohibition if you're not a permit holder unless you fall into one of the other exceptions. So there is a Class A misdemeanor in general. And then in addition to that, local governments have the ability to post, but only if they also provide metal detectors, security guards at every entrance and exit, and bag check. So there is an ability to post in certain circumstances for local governments, but they have to meet all those requirements.
Representative Beck.
So this bill would eliminate any, that Class A misdemeanor that you just referred to, correct?
Legal,
Yes.
you recognized.
Thank you.
Thank you. And Mr. Meyer, would you like to finish up your statement?
unless there's any questions.
Okay. Seeing none, I do have one more I'd like to call up to get his input. That's Josh Warren. Thank you, Mr. Meyer.
Thank you, Mr. Chairman. Thank you, committee members. Appreciate it.
And Josh, if you'll just make sure your red light's on, and you'll just sort of clear up how, and identify yourself, and just clear up how you all post things at the University of Tennessee and what you can contribute to this conversation. Thank you.
Yes, thank you, Mr. Chairman. Josh Warren with the University of Tennessee System, and thank you all for letting me come up here and appreciate the conversation I had with Representative Warner. The University of Tennessee System and all of our campuses across higher education, we don't post. It is an offense either to go armed, which is Class C felony, or it's a Class B misdemeanor if you have possession of a firearm. This bill, as the gentleman explained, we can't pick and choose where individuals carry. If you all pass this bill as written, any adult that possesses an enhanced carry permit can carry in Neyland Stadium, can carry in fraternity houses, sorority houses, our hospitals, mental health, tenure decisions, disciplinary hearings, Title IX hearings, classrooms, anywhere. We can't pick and choose by following this law. One thing I did want to add with here, and one of the notice, when it is a complete rewrite of 1309, and so it completely takes all the language of 1309 out and puts this back in. One of the things it does is it removes the penalty for possession of firearm on our campus. So it's not just, we don't know how our law enforcement officers are going to respond because there's no penalty anymore. There's no penalty for either the intent to go armed with weapons, whether that's explosives, blackjacks. I know we mentioned tasers, but also there's no Class B misdemeanor for the just sheer possession of a firearm. And of course, the way the bill is written now is our full-time faculty and staff are only allowed to carry handguns under the enhanced carry permit. This allows firearms. So any adult faculty, staff, student, or just fall fan or mock fan can carry a long gun on our campus in these places.
Thank you. Any questions for Mr. Warren? Representative Todd.
Thank you, Mr. Chairman. Currently, does the campus provide guaranteed security for every person that enters the property? I mean, are you liable for every piece of property that comes on your property, car, personal property, and individual? Are y'all liable for every single person that comes on that? Anything happen, protecting them completely from all harm?
Mr. Warren.
Getting a little bit out of my expertise, but no, I would say that we're not liable, particularly for every person on our campus. I think that's a liability that's hard to guarantee.
Representative Todd.
Thank you. And similar to that, are you liable for their safety? is your police force, your security force liable for people's safety? Are they absolutely obligated to protect every single person on there that we are disarming under current law?
Mr. Warren.
Great question. I would say that our law enforcement officers across our campuses have an absolute obligation to protect our campus community. And I would say, look, we're not gun-free zones. And so, for now, if you're a full-time faculty or staff member via the enhanced carry permit, you notify law enforcement, you can carry on campus. A couple of our campuses, I believe at Knoxville, it's 300 of those individuals. As far as student carry, no, there's not student carry, what I'll call the core academic space, dormitories, housing. But, working with you all, you've passed a series of measures. One of the conversations you've always had is, where does the property right and the Second Amendment right hit, particularly with commuter students or workers? Any adult, whether that's a student, a visitor, or guest, can carry in their vehicle. So that student that's on campus, that's, commutes off I-40, we've heard had a flat tire in a bad area of town, they can carry a firearm. We also all of our campuses store weapons for faculty and staff for free. You can imagine UT Martin, for instance, has a large number of shotguns as duck hunting out there, but we're not necessarily a gun-free zone. But great question, thank you.
Representative Todd.
Well, and you heard the testimony earlier from the young lady that had mentioned the issues at UT Martin some years ago. And, I think you agree that you cannot protect every single person. And, if we're taking away these adults, and we're not talking about minors, we're talking about adults, and take away their right to keep and bear arms and protect themselves, which they're personally responsible for their own protection in this country. And we know for a fact that law enforcement absolutely is not liable to protect us. Many of them lay down their lives to protect us, but they're not obligated to or liable to. So I think that gets to kind of the heart of what this is about the personal protection that we should allow under our civil rights that are guaranteed by the Constitution. So I thank you for being here and giving us your perspective on this.
Thank you, Mr. Warren.
If I would just say, Mr. Chairman, we can't protect students with or without more guns on campus. So I think there's some instances where the increase of firearms also creates their own challenges, but completely respect and understand your point.
Thank you. I don't think we got any more questions, so thank you. And members, without objection, I'm going to go back in session real quick and ask the sponsor that it seems like there's some more work we need to do. Would you like to address that?
Yes, sir. I want to reference a point he made there at the end. He mentioned faculty and staff was able to carry firearms on campus. Why in the world would we as a state allow faculty and staff to protect themselves and not these young women? They're adults when they enter college. They'll get the enhanced gun carrying permit, and they will be able to protect themselves. We should allow them to do it. With that, Mr. Chairman, I am going to ask for you to let me roll this bill 1 week and make some changes.
Thank you, Representative Warner. Without objection, House Bill 977, rolled 1 week. Next up, item number 3, House Bill 795. Do I have a motion and a second? And Representative Kepley, you are recognized.
Thank you, Mr. Chairman. If you would allow it, I'm just going to make a few comments before we kind of get going here, if that's okay.
That would be wonderful.
Thank
You're
you.
recognized.
Ladies and gentlemen in the audience, thank you all so much, especially those that are wearing your 2A shirts. We really appreciate you. It warms my heart to see Second Amendment loving patriots in the audience today. But unfortunately, I'm struggling, and I'm not going to pass the buck on this bill. This bill is 100% my fault. I've been working on this for weeks. I've made amendments to it, and unfortunately, it's a very difficult subject. I'm not going to blame any department. I'm not going to blame any organization. I'm not going to pass the blame on anyone, but I'm going to apologize to each and every one of you because I could have done more. To the people at home, I want to apologize because I could have done more. Throughout the campaign trail, I had promised everyone back home that I was going to fight for our Second Amendment rights and increase those rights going forward. But today, I've failed you, and I want to apologize. I think going back, I don't know what more I could have done, but clearly there's some more work that needs to be done on this, and that's okay. But again, I just want to make it very clear that this is not an entity's fault. It's not another individual's fault. This is just a situation that we couldn't we couldn't work out, and it's unfortunate, and it's completely on me. So I want to apologize to you. Mr. Chairman, if you'll allow it, I'd like to roll this to special calendar.
And thank you. And Representative Farmer, you're first on my list.
Yeah, I just want to follow up on Representative Catley's comments. He has worked very, very hard at this. I know Leader Lambert and I were here when we worked on this initially a few years back, and the problem is this: it's nothing to do, and I don't think you have anything to be apologizing to your constituency about, because I know how hard you've worked, and this committee knows. Anybody that knows you knows that too. But I think the issue comes down to this: is in this state we have courthouses. We have some of the oldest, most beautiful courthouses you can find anywhere in the country. We have justice centers. We have municipal areas where city councils meet and that and the other. So in the courtrooms are sometimes courts are held in an old courthouse where maybe one courtroom over here and a courtroom over here, or some people have. Some counties have justice centers. If every county had a justice center, this would not be an issue. But unfortunately, some of these counties, just like the one I reside in, Sevier County, they have court in our old courthouse. It's been there for years. We don't have a justice center. Over in Jefferson County, another county I represent, they have a justice center. We also hold court in some municipal areas, city halls, and this, that, and the other, like in Sevierville, one Wednesday of the month, and in Pigeon Forge and Gatlinburg. So it kind of rotates. So once you take all that in consideration, this gets to be really, really tricky. And it's not that anyone in this committee doesn't want this to pass, because we do, but it is a mess to deal with. I mean, we worked very, very hard to get it where it is now, and I just commend Representative Capley on taking it on and trying to make it even better. So I just want you to know, sir, we appreciate all your hard work, and just want to let the folks out there know just kind of some of the things we're dealing with, and it's just not black and white on the issues across this state. So I think it's more of an infrastructure problem than anything, coming in with not every county having a justice center just specifically for courtrooms and the judicial process. So just wanted to let that be known.
Very well said, Chairman Farmer. And Representative Todd?
Thank you, and I would also echo those comments, because you, sir, have worked very hard on this. You have worked with a number of members of this committee to express your concerns, to deal with concerns expressed by others. We've been back and forth. You've amended it and drafted other amendments, and folks still have not been happy with it, because again, it is a complicated issue. And if we could just say in a very simple bill that any of our public buildings that where court proceedings take place, that law enforcement will make sure that no one can bring a firearm in that courtroom, but everything else you can protect yourself. That'd be simple, but you can't write a law quite like that and quite that easy. So the nuances of this are just difficult. So you have done a tremendous job, a very commendable job in this. So you don't owe an apology. But thank you, Mr. Chairman.
Thank you, Representative Todd. And Representative Parkinson.
So first, let me thank y'all for explaining what the two-way was, because I was sitting here racking my brain and Googling what the two-way was for, and then it's like, duh, okay, Second Amendment, okay. Y'all, look, it's been a long day. I needed some 5-hour energy drink so I can bring myself back. I needed some wings, and but to the freshmen, man, look, Representative Capley, don't hang your head, man. You're in the Tennessee legislature. Trust me. Look, you get 3 to 5 bills passed up here this year, you're doing very, very well. For us Democrats, if we get one passed in a year, we're doing extremely well. Right. So, but now I'm not saying I would have supported your bill. I don't know what it is, but in a lot of cases, I look at my state representative up here, Bill Beck. He probably wouldn't have supported it either. But it didn't matter. It wouldn't matter if we supported it or not. Honestly. But I'm just saying that honestly to say, man, listen. Keep fighting for what's right. Don't hang your head over bills that you don't get, because you're not gonna get them all. So, and if you take it personally, you're gonna be apologizing the entire time you're up here, because you win some, you lose some, and so I just want to give you that advice, as my freshman colleague across the aisle, man. It's all right. Thank you.
Thank you, Representative Parkinson. Leader Lambert, you recognized.
Thank you, Mr. Chairman. I was monitoring from the back room. I appreciate that heartfelt apology. I know others have said this. Look, it got rolled to the special calendar, and we're in the first year of 2 years. I tried 7 years ago, and so did Chairman Farmer, every justice center throughout the state looks differently, every courthouse is used for different things. There is a way to get to a solution on this. And I've never seen anybody try harder than you have to try to figure that out. So you have nothing to apologize for. I appreciate you doing so, and I'm sure your constituents do as well. But it took me 3 years to pass a bill that I was extremely passionate about here when I first got elected. You've probably passed more bills in your first few months than I did in my first year. Hurts my heart to admit that, but you've done a great job on this. And I know it's a love fest in here right now, but everybody needs to understand you've done everything you can. It's just a difficult thing to try to work out on how you deal with courtrooms and courthouses, and they're different throughout the whole state. Gino's been in all of them. You can ask him. So thank you, and I just wanted to add my applause as well in your hard work on this bill.
Thank you, Leader Lambeth, and I concur with everybody else says. Representative Calpe, you're just a fighter for the Second Amendment. It's noticed. We appreciate all of y'all supporting Representative Calpe and the Second Amendment, and I hope you keep up the great fight that you're doing. So without objection, House Bill 795 wrote to the special calendar. All right, seeing no other business, without objection, we stand adjourned.